afternoon, good morning, good evening, whichever part of the world you're joining in from. I'm so excited to kickstart the third annual Comparative Animal Law Workshop. So as you know, this workshop has been running for the past 3 years and is a collaboration between among the Faculty of Law and Political Science, the Center for Animal Law Studies at Lewis and Clark Law School, USA, Kent Center for European and Comparative Law, the NALSAR University of Law, the Faculty of Law in Romania, the South African Institute for Advanced Constitution, Public and Human Rights and International Law at the Center for at the University of Johannesburg. So this is a huge initiative that's so global and so diverse, and that is reflected in our very exciting lineup today, where our speakers are joining in from a wide range of countries and talking about a wide range of topics that are so relevant to animal law and the future of animal law, and we're very excited to dive right in. But before that, I think we have the exciting keynote address, and I will let Alexandra sort of take it from here. So before that, I just want to briefly introduce Alexandra. Dr. Alexandra holds a master's degree and a PhD in comparative law in Sorbonne and is currently an assistant professor of law at the University of Timisoara, Romania, where she teaches philosophy of law and legal theory. She's also a member of the Coordinative Council of the Nomos Center for International Research on Law, Culture, and Power, and a co-editor of the corresponding series at Rutledge. I also want to just add a quick note on the presentations that we'll be listening to today before we hear about the keynote address on commodity, irreplaceable property, or subject of rights, the multifarious legal status of animals. We have a presentation by Jennifer from Lewis and Clark Law School. We have a presentation by Noyanika from Assam, India, followed by a short break, and then we'll have a presentation by Emmanuel from Vermont Law School and Rosa Maria from the University of Basel. And we have a presentation by Kurki, who was also one of our presenters last year from Sri Lanka. And finally, after a short break, we will have a presentation by Dikshita, who is also from India, and Chloe from France. They're going to be talking about issues from cultural traditions to addressing trophy hunting and looking at international conventions such as CITES and CBD. So I hand it over to Alexandra.
Thank you, Shreya. Welcome, everyone. And of course, a big welcome to our first keynote speaker. So we are most honored to have with us today Professor Vesa Kurki, who's an associate professor of jurisprudence at the University of Helsinki and also the director of the Helsinki Animal Law Center. His doctoral dissertation on legal personhood, which he obtained from Cambridge University, was awarded 2 important prizes. It was published by Oxford University Press in 2019, and the book was described as an instant classic in the Modern Law Review, and it has been cited in several cases involving animal personhood in the United States. Importantly, in 2023, Professor Kurki was awarded an ERC, starting grant to investigate agency in law. So we're most happy to have you today. Shreya already mentioned the title of your presentation, so with no further ado, I give you the floor. Thank you so much.
Yeah, thanks so much. Thanks for the invitation, and again, congratulations on putting together this great event. I'll now try to share my screen. Let's see, is it this one? There we go. Right. Yeah, so unfortunately I can't stay for the entire course of the workshop. I'm actually currently on parental leave and working only 2 days a week, and there's so many things packed into those two days. Can you see the screen now? Yeah, good.
Yes, we can see it.
Good, yeah. So I won't be talking about, I mean, I know my earlier work has much work focused on legal personhood, but I won't exactly be talking about legal personhood. That will be one topic here, but more recently I've been interested in sort of trying to understand the legal status of animals. What exactly is it currently, where is it headed, and so on. And actually I should maybe say that I don't think there is a single legal status, but rather there are various different legal statuses. This will be maybe somewhat Eurocentric to some extent, but I think these analysis can be applied to other legal systems as well, Western legal systems. I'm not sure about, for instance, indigenous legal systems. So this is a sort of a descriptive approach primarily. So much of my theoretical work has been sort of, I think it's sort of a niche, which is doing sort of theoretical philosophical work, but primarily doing it with a descriptive aim. So trying to understand where the law currently stands. So for instance, with legal personhood, I've just been trying to understand what does it mean to be a legal person, and not necessarily to give a theory of why animals should be legal persons. The idea has been more to provide a coherent understanding of what it means, and then we can start doing the normative work after that. This talk that is sort of my personal result, the sort of what I achieved during a research project we had here in Helsinki called the Anywhere Project, Animals Under Welfarist Regime, which became sort of the Helsinki Animal Law Center. So we have quite a few people here in Helsinki doing animal law, actually. It depends on how many you count, but I would say we have maybe 8 people who do animal law in Helsinki. Most of them are PhD students, but also postdocs and so on. And by the way, we also have, for instance, we welcome visitors. We usually can't offer a whole lot of money to the visitors, but we can definitely offer a workspace and a company and so on in case anyone's interested in visiting Helsinki at some point. So this is a publication that I recently, the left-hand article here on the left-hand side is sort of what I've mostly been talking about. You can find it in the Modern Law Review. It's open access. And I'll also be using some of my sort of work on legal personhood here. So some of the main claims I hope to make here are, first of all, I want to dismantle some traditional binaries about the legal status of animals. One is sort of is it a binary or not? Animals are things. This is that you very often hear when we talk about animals' legal status, that animals are things or commodities or something like that. And I would argue that, well, some animals are things, others are not, actually. And that the legal thing of animals is of a special kind. And there are some developments in Europe, but also some other parts of the world where it's increasingly developing into a special kind of thinghood, especially for companion animals. And this is sort of the second part of the binary. Since animals are things and so-called legal objects, I think this term might be familiar at least to sort of civil law people here. This means that they cannot hold rights. I'm not going to focus on this much, but actually I would argue that protected animals already hold some thin rights, and that's why they are subjects of rights already. And since you are mostly research students, PhD students, and so on, I also wanted to briefly discuss this sort of methodological claim that I also make in the article I just briefly mentioned, which is that when we do this kind of analysis about the legal status of animals, we should engage in what I call substantive analysis rather than a formal analysis. And what I mean by this is that we should not look at what words a legislator uses. I mean, of course, we should look at them, but we should not sort of be bound by them. So some of you might be familiar, for instance, that in many European countries, there's been this sort of a relabeling of animals. So for instance, in Germany and some other German-speaking countries, animals used to be, the word the legislator used to refer to animals was thing. But now they've said, for instance, in German civil code states that animals are not things, but they're animals. However, the legal rules we use to sort of that apply to things also apply to animals. So basically, animals are still things according to this substantive analysis, because we should look at the actual norms and not the labels. Right. So this is first what I call inventories of the universe. It's a rather grand term, but these are sort of pictures I've drawn, especially on the left-hand side, what I call the formal inventory of the universe, or the orthodox inventory of the universe. This is the way I think most lawyers and jurists and legal scholars learn to think about persons and things and subjects and objects. So there's this sort of a very clear black and white idea that you're either a person or a thing. If you have even a single right, then you're a person. And animals are things, therefore they cannot hold rights, for instance, and so on. But I myself have offered a theory of legal personhood and also increasing legal thinghood, where these are much fuzzier categories. So you have sort of clear cases of persons here in the middle, clear cases of things here in the middle, but there is sort of quite a bit of flexibility between these categories. So if you think about, for instance, how women's legal status has developed in most countries over the centuries and so on, it's not that women first were things, like 100% things, and then became persons, but rather women have sort of developed from the outskirts of personhood to full personhood today. And there are some other examples like this. Or if you think about fetuses, for instance, so I wouldn't classify fetuses as things, not really as persons either. Rather, they might be sort of outside of this dichotomy, even though I think they have some rights. So maybe put them somewhere here. But we're not here to talk about fetal personhood. These are just some examples of how I tend to think of these things. And this picture here is more specifically about the legal status of animals and how I come to think about it. And you should think of this as a sort of a historical development starting from in the Western case from ancient Rome and then sort of developing from there. So here we have first what I call the classical thinghood regime, which is actually most of Western history has been just pure classical thinghood regime, where animals have simply been things, though a bit of special things. And then starting maybe roughly from the 19th century, we've started having two, I would say, sort of mutually, I wouldn't say maybe contradicting, but two trends that are somewhat in tension with each other. One is what I call the modern exploitation regime, where we exploit animals very intensively in various ways, in new sort of modern ways. We use them for experiments and factory farming and so on. But at the same time, we've had this development where we treat animals as not mere things. And actually here I use maybe the word regime a bit too many times on this picture. But there are basically two types of regimes that apply to animals at the same time. A regime here means like a set of legal norms. One I call the commodity regime, which treats animals as commodities. And the second is what I call the more than commodity regime. And here, animals are not simply commodities, but something more, as the name would maybe imply. And I'll go through these briefly now, and then go a bit more deeply into some of them. So first, for most of history, we had what I call the classical thinghood regime, where animals are mere things, but they are still special kinds of things, even in ancient Rome. And why are they special? Because you need special kinds of legal rules to regulate animals and human-animal interaction. You need to account for things like the fact that an animal can run away, but your dog cannot. So what happens if an animal runs away? If you read sort of classical Roman law texts, there is already discussion of these kinds of cases. So like a wild animal, how can you obtain ownership of a wild animal, and what happens if that wild animal runs away, and so on. And if you have bees, what happens if the bees make a nest, on another person's land, and these kinds of things. Whoops. Then we have the modern exploitation regime, which I already mentioned. Here, the sort of commodity approach to animals is still in place, but it becomes more intensive. And what unifies these two sort of regimes or approaches is that they treat animals as commodities. And commodity here is a particular type of thing. It's a particular type of property or piece of property, which is replaceable. And I think it becomes clear if we consider an irreplaceable thing. And this is where the more than commodity regime comes in. So the more than commodity regime has three sort of primary strands. One I call irreplaceable and familial property. So this is sort of a private law development where especially companion animals are understood as special types of things. And there's status as animals is modified, status as property is modified. Then we have animal protection, where we protect animals as sentient beings, and their property status is limited. And then we have animal conservation or wildlife law, where we protect wild animals because of their species. And in fact, there are some cases where I argue this will lead to an abolishment of animal status as things. So starting with irreplaceable and familial property. So what I mean by irreplaceable property is that, and this doesn't apply to all countries, but it applies to some Western countries already, and some in case of some animals. So basically, the companion animal's legal value is not their market value. So you can't simply replace one animal with another for the purposes of tort law, for instance. So if you think of, for instance, so let's say I harm your dog, I kick your dog or something like that. And let's now consider the tort law consequences of me doing that. So let's say that the vet costs would be 1,000 euros, and you're getting or me buying you a new dog would be 200 euros. So which one do I have to am I liable to pay 200 euros or 1,000 euros to you? Well, according to the sort of old way of thinking, the sort of commodity approach, I would only be liable to pay 200 euros because your dog is replaceable, right? I can just get you a new dog, and then the economic damage I've caused you is sort of settled. But on the irreplaceability approach, I would have to pay even 1,000 euros because it's not just any dog, it's this particular dog that has special meaning to you that I've harmed. And you can see some European countries, I'm not sure about, for instance, the US or India or other countries, but I've definitely seen some European countries do this. Or implement this new approach. I can remember if I had an example of Sweden in the next slide, but Sweden would be one example. And then another development is something that I call familial property, which is about the determination of ownership over animals. So here, the ownership over companion animals, this is again mostly about companion animals, is determined partly by the bonds the animal has formed with human beings. So here we have a picture of an interspecies family. So if, for instance, you have a divorce case, on the commodity approach, that's sort of traditional approach, you don't consider the special bonds. Yeah. So we have a divorce case, and the spouses are having an argument about who would get the family dog. So according to the commodity approach, which, for instance, the Finnish law would be one example of, so you just look at this sort of you treat the animals like any other piece of property. So things like maybe who bought the animal, who is the animal registered to, and so on. And that's all there is to it. Whereas the sort of familial property approach would be that, no, you also look at who would be better at taking care of the animal, who has stronger bonds to the animal, and these kinds of things. Right, so there's the Swedish case. I should mention that this whole development about irreplaceable and familiar property, so it's really very anthropocentric. It's not a sort of a recognition of animals' intrinsic ultimate value or something like that. It's just a recognition that companion animals are more important to their owners than, let's say, mobile phones, with the limited exception that sometimes, for instance, in the case of familiar property, if you look at some European countries, the judges might also have to consider who is best equipped to take care of an animal. And I think that's more than an anthropocentric consideration. So this was one example of the more than commodity regime. So this is just one example from the Swedish Supreme Court. Then we have the animal protection, what I call animal protection, basically, and what results this has had for animals' legal status and animals' status as things. And this is a bit contested. And I think there are two opposing approaches to how we should understand animal protection today. I've classified or like sort of encapsulated this in terms of the question of whether animals already have legal rights, but there are some other issues here as well. So one approach is to say that we protect animals already, but they're not legal right holders because we don't protect them strongly enough. We haven't given them rights explicitly, so the law doesn't talk about animal rights in most countries. There are some countries where the law does talk about animal rights, or judges talk about animal rights, because animals are not legal persons, whatever that means, or because animals cannot demand their rights. And so this is, I think, sort of the traditional view, how we would understand animal rights in terms of the law of today. But then there's this another conceptualization which says that actually animals already hold some limited legal rights, because even weak protections can entail rights, because it doesn't matter what animal protection statutes say. It doesn't matter if they talk about rights. But what matters is the sort of what a right means, because one can hold legal rights without being a legal person, and because rights are about interests, so not demands. So it's not a requirement for animals to be able to demand their rights in order for them to hold rights. And this is the so-called interest theory of rights, which is quite standardly applied to children as well. Young babies cannot demand their rights, but still they can hold rights. And this is perhaps a more recent view. It's the view I personally favor, and it sort of fits quite well with this. So I would argue that protected animals, so of course not all animals are protected. If you think of the United States, for instance, the Federal Animal Welfare Act actually doesn't protect all animals at all. I mean, protect some animals, but not all. So I would argue that those animals that are protected in this way, we've given them some limited welfare rights. They have moved a little bit from the center of thinghood, a little bit this way. They're not persons, but they already hold some limited, thin legal rights, and that's why I would call them already that they're subjects of rights, even though they're not persons. So this was a brief foray into animal protection. So far, I've said that there's this new approach to companion animals whereby their status as property is modified. So we have new rules that apply to their status as property. then animal protection is about limiting their status as property. So the owner of an animal cannot do all the things that he or she can do to other pieces of property that he or she owns. And then we have animal conservation, so protection of wild animals because of their species. And here I would argue, and again, this is a European example. I'm not sure, I really don't know how this would apply to countries outside of the EU. But I would argue that some strictly protected wild animals in Europe are not things at all anymore in Europe. So first of all, how have wild animals been conceptualized in sort of in the traditional, what I call classical thinghood regime? So there's been two options. One is that they've been classified as res nullius, which is Latin for things owned by no one. And I think this is more prevalent in Roman law. It was the approach in Roman law, and it's quite prevalent in civil law systems. And then I think some common law jurisdictions classify wild animals as owned by the state. So both treat animals as things and as property. But if we now actually look at, I take the EU Habitats Directive. So this is binding law in the EU. So this is a bit of a legalese. But there are certain species that are under a system of strict protection. For wolves are one example, at least for now, though they're not trying to get wolves reclassified. So these things are prohibited in the case of wolves. Deliberate capture or killing, deliberate disturbance of these species, as well as the keeping, transport, and sale or exchange, and offering for sale or exchange of specimens taken from the wild. Another question is that if we have animals like wolves, who you cannot capture, kill, disturb, keep, transport, sell, exchange, are they still things in any meaningful sense of the word? Because isn't that what being a thing or property, isn't that what it's about? That you can kill them and keep them, transport them, sell them, exchange them, and so on. All of this is prohibited. So I would argue that at least these animals protected, encompassed by these protections, they're not things anymore. I wouldn't straightforwardly classify them as persons either, but I wouldn't say they're things. So here we have one example of sort of why, or another example why we need to stop thinking that animals have a single legal status. So this is very preliminary, but this is just some ideas of how we could classify some groups of animals. So if we first consider animals used for production, their status in private law is still that of a commodity, so they're replaceable things. So if I kill your cow, I can just buy you a new one. I don't have to take the cow to a vet if that's more expensive. They're afforded some protection, or if they're afforded some protection on welfare grounds, then they would be protected commodities. If they have no protection, then they are mere commodities, according to this labeling. Then we have companion animals in some jurisdictions. Again, this is not the case in all jurisdictions. So some of them are not commodities in the eyes of the private law anymore, but rather what I call irreplaceable and or familial property. And they're also afforded some protection. So hence you could maybe label them as protected family members. Though this might be going a bit too far, but maybe, at least in some cases. I think the new Spanish law is actually quite explicit about this. And then if we consider wolves or other strictly conserved, strictly protected wild animals in the EU, they are sort of outside of the regulation of private law. They sort of, because at least as things, because you cannot own them. You cannot sort of, they cannot enter into private law as things for most purposes. they're also quite strongly protected, both on conservation grounds and to some extent on welfare grounds. So there's both protection of their lives and so on, so that their species can go on existing, and then they're also protected from cruelty and unnecessary suffering and so on to some extent. So here is just one possible label. It could be strongly protected wildlife. And actually, all of these I would also classify as subjects of rights, except mere commodities. These kinds of animals are not subjects of rights at all, not even of thin rights, unfortunately. So to conclude, and then we can have a discussion. I'm looking forward to it. So I don't think there is a single legal status that all animals fall under. I don't think there's any label that would work for all animals. If we call them things, well, not all animals are things. Some civil lawyers have started using the word legal object, but if legal object means an entity without rights, that's also incorrect, because many animals already hold thin legal rights. So it's a multifaceted, multifarious issue for what the legal status of animals is exactly. But that's why we need a nuanced approach to this question. So thank you very much, and I look forward to the discussion.